Today's presentation is in association with the Affordable Housing Coalition. I am also a member of that coalition, and I don't know why the timings are on, but anyway, we're talking about Bill 184, and there's going to be some extra bonus material as well. This presentation contains general legal information about Bill 184, as well as some opinion from me about why this is an important bill and potentially prejudicial to tenants. But it's not to be used for legal advice in any specific legal situation. If you or your client is facing a legal problem, please contact us. So a brief history of the bill. It was first introduced on March 12th, 2020, just before the pandemic really took hold. And many thought that the bill would be withdrawn as a result of the pandemic. It was really designed to deal with problems at the Landlord and Tenant Board and some complaints that the Landlord and Tenant Board and the government had been receiving, both from landlords and tenants. I am getting some background noise from some participants, so if you could mute your self down at the bottom left-hand corner, that would be great. However, the government surprised us and brought it for second reading on May 26th. And this was despite the fact that they'd made kind of a handshake agreement with the other parties, saying they'd limit business in the spring to COVID-related items. So the Standing Committee on Social Policy considered it in June and July, and most presenters were tenant side, and they brought some serious concerns, especially around some of the procedural issues in the bill. However, there were fairly few amendments accepted. The bill then received royal assent on July 21st, 2020, and the City of Toronto has challenged the bill, but they kind of acknowledge that the challenge is not likely to be successful. But who knows? And the main thing that they're challenging is the first section, and the first thing we're going to talk about today, which is this fast-tracked evictions versus via repayment agreements. Other big changes in the bill include that tenants must give advance notice to raise Section 82 defenses, or those are complaints about the condition of their home or how their landlord has dealt with them at their arrears hearings. Landlords can also now seek costs related to interference or unpaid utilities. Landlords can bring former tenants to the Landlord and Tenant Board. No longer are they limited to when the tenant is in possession of the home. Void rent increases, which we'll talk about what those specifically are in a few minutes. They're now going to become legal after 12 months. And the silver lining, there's increased compensation and disclosure requirements for landlords and fines for no-fault evictions. So why is all this important? This is a really significant change. The changes that were made are really significant, and they'll require tenants to be aware of their rights prior to problems in their tenancy cropping up. And that means that it's really important for them to be educated. Both your current clients and potential client groups that you're dealing with will need to know about these changes in order for them to understand when they need help. And finally, the latest buzzword in the legal clinic community is trusted intermediary. You may have heard it in your communities as well. And you all are trusted intermediaries. You are dealing with people, you are trusted by people who are having legal problems, medical problems, mental health problems, and you can help them identify when they have legal issues and to direct them to legal advice. And so this presentation is to help you figure out what are the new legal issues that this Bill 184 is going to be causing for us. So first, fast-tracked evictions via repayment agreements. This is section 206 of the Act, and throughout the presentation, I kind of structure it with what happened then and what's happening now. So previously, when a tenant owed rent, the landlord and the tenant could agree to a repayment agreement. And after the landlord had served and filed their application, they could ask the board to create a consent order. And this would be an order that, was legally binding on the parties. But the order could not lead directly to an eviction, nor could it allow for what we call a Section 78 term to be included. And that's where if a tenant breaches a term of an agreement, or an order, the landlord can apply to evict them without any further notice to the tenant. So then, if the tenant did breach, the landlord would have to reopen the application. However, this power was rarely used. There's only one case that's I could find publicly reported about Section 206 being used. We expect it's going to be used a whole lot more now, because now these agreements can include a Section 78 clause. And so that will allow the landlord to file for an eviction without notice to the tenant if the tenant breaches the consent order. Some caveats to that: if the tenant feels like they've been unduly pressured or misled into agreeing, they can apply to reopen the application within 30 days of the consent order being issued. A challenge with that is that that means that they're basically saying, I don't like this consent order at all, I'd rather go to a hearing, and it will recreate or reschedule a hearing that would have happened sooner probably than if they had successfully paid off their consent order repayment plan. If they do breach, or if the landlord thinks they've breached and files for an eviction, tenants have only 10 days after the eviction order is issued to file for a set-aside, which is basically saying, yes, I breached, but I should still be allowed to continue the agreement because I've made good, or no, I never breached, the landlord has been dishonest. My concerns regarding fast-track evictions are that landlords control the timing of when to file and serve documents in the eviction process. And as a result, they have a lot of power in that process. And tenants are scared of dealing with their landlords during this process. They want to make things right. And they may not understand how or what their rights are. And we can't trust, unfortunately, that landlords will give tenants good information or referrals. Probably some will, but many won't. And that will lead tenants to make optimistic agreements with their landlords that they think, they're agreeing to what they think the landlord wants to hear without really thinking about whether it will be an agreement that they can live up to. They just want to, buy themselves more time. But there may be good legal reasons for why the tenant wasn't paying their rent or wasn't paying their full rent. And tenants are often unaware of the programs and resources that can help them. There's the legal clinic, there's YSSN, there is, the rent banks that we have in York Region. And finally, 10 days is very little time for tenants to receive an order, generally in the mail, find the legal clinic, and get a motion to set aside filed. So when Josie was speaking, this is what we're concerned about will really speed up the issuing of eviction orders. Tenants must now give advance notice to raise defenses at arrears hearings specifically related to offsetting the amount of money that they're going to be owing. So previously, during a hearing, tenants could raise any issue that could be the subject of an application made by the tenant to reduce the amount that they owed. So for example, let's say that they had stopped paying rent because their kitchen, they had no water in their kitchen. And maybe the landlord and tenant board would typically discount the rent by, let's say, about 15% for that. If that's the case, they would be allowed to raise that issue and get the amount that they owed reduced by 15%, which may then become something that they could afford. If the tenant had never complained about the issue before, the LTB would generally dismiss the tenant's complaints because the landlord would have no warning that this was an issue, no ability to have fixed it in the past. And so that's kind of procedurally, there's some unfairness. And both sides would typically provide the evidence to the other on the morning of their hearing. Now, tenants will have to provide notice to landlords of any of those sorts of issues that they'd like to raise prior to the hearing occurring. And they'll also, at least the proposal is, present their evidence to the landlord before their hearing. We're hearing from the landlord and tenant board that they would like to insist on 5 days notice. This is being challenged right now by the Specialty Legal Clinic ACTO, an Advocacy for Tenants Ontario. They're pushing back and saying, we don't even insist that landlords and tenants provide their evidence around the main issue of the hearing 5 days in advance most of the time. So 5 days in advance for these issues seems to be intense. Now, the landlord can also waive the requirement for notice if the tenant can provide a good reason why they couldn't give notice. So this 5 days in advance seems like it's predicated on the idea that everybody will have access to email. And maybe if you had no access to email, that would be a reason why you couldn't give notice in advance, potentially. My concerns are that many clients withhold rent initially because of concerns about their unit's maintenance or their landlord's behavior. And they don't really necessarily understand that there's an official formal process to complain about maintenance, and they're unfamiliar with the LTB processes. So at the best of times, tenants who are very diligent can miss things in notices or not be familiar with the rules, and this is going to exacerbate that problem. Tenant Duty Counsel, which is what I mean by TDC, will often be able to counsel tenants about their issue and suggest, wait, don't bring your application now, don't bring up your complaints now. Instead, file, take a week, organize yourself, get all your evidence together and file, and you'll get a better, bigger reward back. But that may not be an option for all tenants. If they're going to be evicted and have to leave the area, or if English is not their main language, then the prospect, the ability for them to bring their own application later is less, and this change is going to hurt those folks. As I said earlier, before COVID, parties often didn't provide their evidence to each other until the morning of the hearing. Now they are being asked to provide evidence a few days in advance via email, but if you don't have email and you're being asked to respond to an arrears application, that could be a real challenge. And also, we have been hearing reports that tenants are receiving their notices of hearing fairly close to the date of their hearing. This has to do with, in the COVID period, the fact that they're hearing fewer types of applications, and so they had less on, the LTV had less on their plates, and so they were able to put things closer together. But even in the best of times, sometimes mail comes late or what have you, and a tenant may only have a couple of days to put together their information. Now landlords can seek costs for unpaid utilities or for interference. So previously, when evicting, a landlord could only recover costs for arrears of rent and damage caused by the tenant, for if they put their foot through the wall or something like that. The landlord could evict a tenant if they didn't pay the utilities that they'd agreed to, or for interfering with the landlord's lawful interests, but they couldn't recover those costs through the landlord and tenant board. They could potentially do it through small claims court, but not through the LTB. Now, there's 2 new sections that have been created, 88.1 and 88.2, and they will allow landlords to recover their reasonable out-of-pocket expenses related to both utility arrears and to interference with the landlord's lawful interest in the unit. Those sections aren't in force yet, and probably they'll be put into force once the landlord and tenant board develops new forms for them. The legislation does not require a landlord to file to evict in this situation, but what will actually happen is unclear, because the existing practice for damage claims, for example, is that you're primarily applying to evict and then you're also asking for the compensation. So I expect that it will be similar for this, is that you will apply to evict based on utility arrears or based on interference, and then you can also ask for money as part of that. Some concerns about this are that if the board permits non-eviction cost applications, this may reduce the number of eviction applications that landlords choose to bring. And that, I think, would be a good thing overall. It would mean that people could deal with the financial issue while still letting tenants remain in place. However, landlords already have the opportunity to do this on a rent arrears application. They can apply just to recover the rent. However, last year, 62% of landlord applications were L1s, which are the applications to evict and try to get the arrears of rent back, while only 2% of applications were L9s, which are just for the money. And that number is really probably less than 1%, because at least in York Region, over half of L9 applications are paired with other forms of eviction application. So, probably 0.8% of the time, a landlord files and says, all I want is the money. They can otherwise stay in place. So this will likely make it easier for landlords to be compensated for utility arrears and other expenses. In itself, that's not necessarily a bad thing. However, in practice, utilities can be a frequent area of conflict between tenants and landlords where the terms of the lease are not totally clear. And so arrangements can be unfair to the tenants or just generally unclear. That can be sorted out in the litigation at the landlord and tenant board, but it would be nicer if hopefully it will lead to landlords and tenants having clearer leases related to utilities particularly. Another issue is that landlords can now bring former tenants to the landlord and tenant board. Previously, the LTB only had jurisdiction to hear a landlord's application if they had filed while the tenant was still in the unit. If not, they had to go to small claims court, whether it was for arrears or interference or damage or anything. And this has caused a lot of confusion between the LTB and the court, with different judgments saying that it should be heard at the landlord and tenant board versus heard at the court, and then there are different limitation periods or lengths of time that people have to file. It's caused a lot of confusion. So now landlords can bring applications for any form of cost or compensation, and whether it's arrears, utilities, damage, or interference, for up to 1 year after the tenant has left the unit. And when I say compensation here, I don't mean additional compensation, I don't mean profit, I mean out-of-pocket expenses. And likely what will happen is that the small claims court will now totally get out of the business of making arrears, having to hear arrears or damage or what have you, because landlords will have the ability to go first to the landlord and tenant board. So some concerns or some things to think about. The landlord and tenant board is a less expensive forum for disputes to be tried than in the courts. A concern, though, is that the LTB has less stringent procedural protections, especially in relation to service of documents. And you can imagine a situation where a tenant was fearful of their landlord and so left partly to escape some harassment and didn't want to tell their landlord where they were going. And so in those sorts of situations, they may not let their landlord know, the landlord may not be able to contact them, and the landlord may get permission from the LTB to proceed with a case without first serving the tenant. And that is less likely to happen in small claims court. So I think that there's a greater risk that tenants will not receive notice of these sorts of applications, or will have to give their landlord their forwarding address where they wouldn't otherwise want to. This is a kind of small idiosyncratic one, but it does have an interesting sort of consequence. Void rent increases will now become legal after 12 months. Oh, I'm hearing some background noise, if someone wouldn't mind muting themselves. So previously, previously and still, for a rent increase to be legal, it has to be served 3 months in advance or 90 days in advance. It has to be for the guideline rent increase amount, which this year is 2.2%, last year was 1.8%, and it has to be in writing. And so sometimes landlords wouldn't follow that, and they would give you a verbal notice 1 week in advance. And maybe it would be for $300 increase because their neighbors down the street were renting for that much, and they think they should get to rent for that much. Previously, where a landlord didn't follow those steps of giving it in writing in 3 months in advance, that increase was considered to be void. If a tenant got a void increase, they could still have that increase reversed years into the future and could get up to 12 months of illegal rent increases returned. And where the illegal increase followed the correct process, though, that illegal increase would become legal 12 months after it was applied. Now there's going to be less of a difference. Even if something has been done illegally, let's say you're renting a home and your landlord comes to you and says, just like one did to me last week, they said, my landlord's wants to charge me $800 more per month. And they've told me this in a text message and they want it to apply for October 1st. Well, that's illegal, it's void. And so, but if that tenant now pays that increase of $800 per month for a period of 12 months, and does not challenge that increase for the first year after it's applied, it will become legal and it will create a new floor for rent increases from then on. So my concerns with this, tenants often don't know their rights, especially around rent increases, and they'll wait years before getting legal help, often on other issues not related to the rent increase, but that will reveal that there's been this illegal rent increase. My experience has been that increases that used to be considered void are often the largest. You know, if you're raising the rent kind of not quite in the right way, but you're using the right procedure, you're not normally going to raise the rent by 40% or 20%. It's going to be in the 5 to 3% range. And so these landlords who will give these verbal notices of rent increase often do so with a veiled or explicit eviction threat. You know, either you pay this or I'm going to have to take the unit back because I can't afford to, you know, live on my own anymore. It's just, I need more money. And so they will kind of couch their request for more money in the form of a potential eviction. Unfortunately, yes, if tenants pay the increase for a full year or don't challenge it within the first year, that will be deemed to be a the new legal rent, and that will create a new floor for future increases. So if you increase the rent 2% on $1,000, that's $20. But if that gets increased to $1,500, then your next rent increase becomes $30. So it will have an exponential effect on the rise of rents. And the province's rationale for this change is that, you know, if a landlord has been used to getting money from their tenants at a certain amount for a few years, you know, it would be hard for them to have to go back to paying, to receiving the lower amount of rent. But I think that the real question is the reverse, is that should the landlord benefit from collecting illegally raised rents for years and then, you know, just get to keep that? That seems just as wrong to me. The silver lining is this increased compensation and disclosure for no-fault evictions and greater penalties for bad faith. So previously, compensation for tenants that were evicted from buildings with 5 or more units due to demolition or renovation would be compensated by 3 months worth of rent. If tenants were facing a landlord's own use eviction, then since 2017, they would be compensated with 1 month of rent. Landlords had no obligation then to disclose that they'd done an N12 or N13, which are the notice forms in the past. And if evicted in bad faith, tenants could be compensated, but only for their actual out-of-pocket expenses. So now they've expanded these compensation requirements for all forms of no-fault eviction, whether it's because the landlord is evicting for the benefit of a purchaser, or if they're demolishing a smaller building. And the amount of compensation will be for 1 month in both cases. The landlords will also have to disclose whether they have made similar applications in the recent past, in the last 2 years. And this disclosure, this information can be considered by the landlord and tenant board. And the theory is that if the landlord has twice in the past 2 years, let's say, filed for their own use, probably this is a bad faith eviction and the LTV will feel more empowered to deny it. And then finally, this general compensation award of 1 year's rent is an additional penalty on top of any actual expenses incurred by the tenant. So that's pretty novel in the landlord and tenant board legislation. There is power for the landlord and tenant board to assess a general damages award, but this is the first time it's kind of spelled out explicitly as an option that the board should consider in one of these situations. My concerns with this are, though, that while the penalties for bad faith are bigger and there are some extra hurdles to initiate the eviction, compensation for landlord's own use is really driven by the difference in rent that landlords are getting versus what they could be getting. And why I say that is that I've put this little chart here. Compensation for tenants who are being evicted for landlord's own use, that was implemented in September of 2017, where that orange line is on the chart. roughly, if you want to think about this as a timeline. And as you can see, L2 evictions, which include the category of landlord's own use evictions, has steadily increased as a proportion of landlords' applications from 2014 to 2019. And that increase has accelerated in the last 2 years. And so it seems to me, now we don't know for sure if all of these L2, all of the increases to the L2s come from landlord's own use applications, but anecdotally, it sounds like they have been mostly. And so it doesn't seem like that change of including that 1 month of compensation has really had a tremendous impact on reducing the number of landlord's own use applications. It could be that landlords are really just moving home more or moving back into these properties more and more, but it's hard to know, and it doesn't seem totally plausible. And the fundamental problem here, as I was just saying, is that there's a huge incentive and a growing incentive to evict in order to raise rent, as long as they can charge what they want for every new tenancy. This is called vacancy decontrol, where you have a landlord has the ability to reset rents at whatever they want. And it's not the case everywhere. In Montreal, they have rent control departments that stay rent controlled through various tenants. Same thing in New York City. And so it's something that Ontario could consider adopting, but so far has shied away from. I have a little bit of bonus content. Everything I just said, that's related to Bill 184, but there have been a few other changes that I wanted to touch on because I think they're very important for most of our clientele. Last year, there were the implementation of a few changes to the Housing Services Act, which is the legislation that governs rent geared to income apartments, or most of them. And this was accomplished through the Community Housing Renewal Strategy, which changed a bunch of regulations to the HSA. The main ones to be aware of are that now, if you're reapplying, that while reapplying for a housing subsidy has been streamlined, it's an easier process. Recipients and applicants will now need to provide tax returns. Previously, they could figure out another way of doing it, but now the tax return is basically mandatory. And so it's really important for our clients to do their taxes. People waiting on a waiting list for a subsidized unit will also lose their subsidy after their first refusal. Prior to 2020, tenants got up to 3 refusals. They could pick a selection of homes, and if the first one, it turned out, really wasn't appropriate, they could say no to it. Now, that's no longer an option. The first time they say no, they will get kicked off of the subsidized waiting list. Service managers do have some discretion about whether to count a declined unit as a refusal. I had a situation like that in June where it was just a very messy situation, and the service manager said, no, she can stay on the list. And it's also supposed to be easier for tenants to transfer between housing providers, but so far, I personally don't know what the mechanism for doing that will be. If someone's been evicted for a serious criminal offense in the past 5 years, the housing provider can decline to offer a subsidized unit to them. So this doesn't mean that they've been convicted of a serious criminal offense. It means that they've been evicted. So they had to have committed the offense on their property where they live and been evicted as a result of that. But if that has happened, then the housing provider can just say, no, we're not going to rent to you. And then finally, an asset test has been applied that wasn't previously there or was much less restrictive. If you're on the wait list for housing, the asset limit is $75,000. And if you are already in housing, then York Region has a higher cap of $150,000. My understanding was that, the idea was that with those assets, you could maybe afford a home. You really can't afford a home anywhere with a down payment of $75,000. So I think that maybe this test was really designed for areas other than the GTA, but that's what the legislation allowed, and that's what York Region has implemented. Just a brief update on COVID and some referrals. Evictions are now being processed by the sheriff. That started on August 4th, and kind of tied to that, the Landlord and Tenant Board has begun to schedule and hold non-urgent eviction hearings. and that's kind of gone along with an increase in the use of technology and a greater comfort with it. And so back in April, they were holding basically 20 cases, 20 hearings per month. That's now up to about 5 per day, and they're starting to hold them in blocks over the phone. So yeah, so now if any of your clients had received a notice for an eviction hearing back in February, they should be they should pay careful attention. That they should go to the Landlord and Tenant Board website and check the status of their applications, which they can do. There's a mechanism, a button where you can kind of put in your file number and your postal code and find out what's going on with your case. And it's probably a good idea. Real estate showings and open houses, which turned out to be very contentious during the worst of the lockdown, they're now being allowed. However, OREA and RECO are still both strongly discouraging them. And we are still advising that tenants should expect a high degree of cooperation from landlords when addressing a tenant's safety concerns. These would include things like ensuring everyone's masked, that they've had their hands sanitized, that they don't touch anything in the unit, that if they're coming through with a realtor, that the realtor provide their business card to them, those sorts of things. And for up-to-date information on tenant and other issues, my suggestions are those two websites, clio.on.ca and stepstojustice.ca. Both of those are run by the legal clinic system and the Ministry of the Attorney General. Both have really good information, and so that's where I would suggest you go. I wanted to talk a little bit about mental health, housing, and COVID-19. As many of you have probably experienced, your clients are facing a greater strain, burden on their mental health. And here are some statistics that kind of back up that up. And just looking at that chart, of the top 4 new feelings that people are feeling more, worried, anxious, and bored are way up there. And that's leading to more drinking, more domestic assaults, and general overall worse mental health. I wanted to highlight a program that we run.
Just 1 second. We do have a couple people not on mute. If they can be muted, that'd be great, because we want the recording to be as clear as possible. Thank you so much.
Thank you. So the Legal Clinic hosts the Eviction Prevention Program. This is funded by the Regional Municipality of York, and we've helped over 1,100 tenants since 2008. We have a team dedicated of 2 paralegals and a social worker that focus on preventing homelessness among people with mental health conditions and educating them and folks such as yourself on their rights and options. We work through delaying eviction until alternative accommodations can be found, negotiating with landlords to allow tenants to stay and trying to work something out, and fighting evictions where there are grounds to do so. We partner with a social worker to provide case management support and referrals to outside organizations and resources. And we provide training to other organizations like yours to help you folks better understand the eviction process and tenants' rights, particularly with respect to mental health. Finally, a couple of upcoming issues and trends that I think that we should all be hopefully paying attention to. We're likely going to see more rent evictions and demolitions, even with the changes that the Landlord and Tenant Board has implemented with respect to these sorts of demolitions. Larger landlords even may now be tempted by the difference between the market rents and those that they charge their tenants. And these types of evictions seem to be increasing. And unfortunately, they often target the low-cost private market housing that there is. So I expect that in the coming years, we're going to see more rent evictions and demolitions, especially of low-cost housing. There's also something to keep in mind is that right now we're in a period where a lot of federal operating agreements with social housing providers are ending. In the 1980s, the federal government funded co-ops and nonprofits to provide subsidized housing, and these agreements were often of the length of 35 years or tied to their mortgages. So now housing providers are losing their subsidies, and while there is a pool of money in the National Housing Strategy to replace those subsidies, that is voluntary, and some housing providers are choosing not to sign up for that. And that's going to basically just say, you know, your rent's going to go from 800 to 1,400, let's say. And the explanation is, well, we're no longer receiving the subsidy. And so you no longer get the subsidy, and you're going to make up the difference. And then finally, we still don't really know what the fallout from Bill 184 is and from the resumption of evictions in the pandemic. We're predicting that many people will be pushed into repayment plans. We don't know if that will be the case. We don't know if tenants will have the presence of mind to choose realistic repayment plans, or if landlords will be offering ones that are kind of working with the tenants as the government has urged, or whether it will be more at a cost recovery sort of mentality. And we also don't know how the LTD will deal with pandemic-related evictions and pandemic-related arrears. They are explicitly now in the Act directed to consider whether the landlord and tenant have tried to work out some sort of agreement, but we don't know whether that will be a positive or a negative for tenants overall. It's too early to tell. So thank you so much for that. There's my information, and I'm going to be posting on the chat 2 things. One is a document that has all the links that I've used to pull information for this presentation. And the other one is a link to a survey that I'm hoping that you folks can fill out to help us improve our surveys in the future, or our presentations in the future. Thanks very much.